I'm Joanna Moody and I specialise in children law at Dean's Court Chambers. The topic I want to talk to you about today is vaccinations within the sphere of public law proceedings. And whilst I'm concentrating on public law, I will, however, at the end of this talk, touch very briefly upon the implications for private law proceedings too. The focus of this talk is the Court of Appeal's recent decision of Re H, which was decided in May of 2020. Just prior to that decision being made available, I represented a local authority in care proceedings where an issue arose between the local authority and a parent as to whether or not a child should have routine vaccinations. The parent in that case was opposed to it, and in accordance with usual practice, the local authority had to make an application for leave to invoke the inherent jurisdiction of the High Court. The case was therefore determined by a Deputy High Court judge. What Re H deals with is the issue as to whether or not a local authority needs to now make an application for leave to invoke the inherent jurisdiction, whether the case needs to be determined by a judge of the High Court, or whether a local authority can simply rely on its powers pursuant to Section 33 of the Children Act of 1989. Lady Justice King gave the lead judgment in Re H, and very helpfully, her ladyship went through the previous cases which have been decided on this issue. And those cases relate not just to public law proceedings where there has been an issue between the local authority and a parent, but also there have been cases determined within private law proceedings where parents have disagreed with each other as to whether or not the child should have routine vaccinations. What is interesting to note is that in each of those cases that have been determined by the court has always allowed the child to have the routine vaccinations. Indeed, no counsel before the Court of Appeal in Re H could direct the court to an authority where a court has refused for a child to have the routine vaccinations. And this was a point also made by Mr. Justice Hayden, who was the judge at first instance. Let us remind ourselves what Section 33 says. This is the part of the Children Act, the section of the Children Act, which confers parental responsibility on a local authority and sets out that the local authority has the power to determine the extent to which a parent may meet his parental responsibility for the child. It's not the intention of this talk to go through all of the prior cases that have been determined. I will start with Re SL, which was a case determined by Mr. Justice MacDonald in 2017. The reason why I start here is because this was a case where Section 33 first arose as a possible alternative route to determining such issues. However, Mr. Justice MacDonald took the view that the gravity of the issue as to whether or not a child should have vaccinations meant that Section 33 was not an appropriate way forward. And in those circumstances, the local authority was right to have made an application for leave to invoke the inherent jurisdiction of the High Court. We move forward now 3 years, and this is Mr. Justice Hayden's decision at first instance. And he took a different view to Mr. Justice MacDonald. He took a view that vaccinations were not medical treatment as such, but were preventative health care. They should be regarded as being at the least intrusive end of the scale of intervention, and he could see therefore no reason why vaccination should not fall within Section 33 of the Children Act. That, of course, is subject to the caveat that each case and each child must be determined on their own merits. there may be cases where there are counterindications, which mean that it's not appropriate for a child to have vaccinations. So he wasn't setting out an approach which applies to each child, but rather that if there are no contraindications, then there's no reason why a child should not have their vaccinations, and no reason why the local authority should not simply proceed by way of Section 33. So that was the issue before the High Court. Is the issue of vaccination so grave that it necessitates an application for leave to invoke the jurisdiction of the High Court, or can a local authority properly consent to that approach to the vaccinations by way of Section 33 of the Children Act? The Court of Appeal favoured the approach by Mr. Justice Hayden. It considered that scientific evidence clearly establishes that it's in the best medical interest of the child, generally, to have vaccinations unless there is a specific contraindication. Therefore, under Section 33, it was appropriate and quite proper for a local authority to arrange and consent to a child to have the vaccinations, notwithstanding the objections of the parents. Of course, the parents' views must be taken into account, but they are by no means determinative. What then if you represent a parent who continues to object to their child having vaccinations? There is, of course, a remedy available to them by way of injunctive relief. But Lady Justice King addressed this in her judgment in Re H, and she said this: an application to invoke the inherent jurisdiction or to seek an injunction with a view to preventing the vaccination of a child in care is unlikely to succeed unless there is put before the court in support of that application cogent, objective, medical and/or welfare evidence demonstrating a genuine contraindication to the administration of one or all of the routine vaccinations. It would appear, therefore, that a parent may well have an uphill struggle in seeking to prevent the vaccinations taking place unless they have good medical and/or welfare evidence available to them. I did say at the beginning of this talk that I will touch very briefly upon the implications of Re H for private law proceedings. Lady Justice King made it clear that in this case she was not dealing with private law proceedings, because of course public law proceedings and private law proceedings are very different, not least because there is a local authority involved within the public law proceedings who shares parental responsibility. And that is where Section 33 comes into play. In private law proceedings, however, there are two parents, two equal parents who each have a say as to the welfare of their child. And it appears that where there continues to be a dispute between parents, then there is no option but to come to court and seek to have the court make the decision on behalf of the child. It may be that in the future, given the approach taken by the Court of Appeal to routine vaccinations, that is to say, that they are not necessarily grave, they are not at the intrusive end of intervention, that the private law approach may be different. But that is for a different day, and that is possibly for a different case. Thank you for listening.